can I put my property in a Medicaid asset protection trust when I have a mortgage? Oh, hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Hey folks, today's question is a two-parter, and it's a very common question that we get from folks, and the subscriber to our YouTube channel sent in these questions. Hey Patrick, now that we put our home in an irrevocable Medicaid asset protection trust, can we take out a mortgage? Okay, and we're going to answer that question. And the other question, the other part of that is, hey Patrick, we have a mortgage on our home already. Can we put our house still in a trust? Okay, I'm going to address both of those questions today, folks, because they are real world practical questions that we hear almost on a weekly basis. So folks, so these are the rules of engagement, okay? If you have a mortgage on your home and you want to put your home into a trust, can you do that? The answer is typically yes, okay? But it's a little nuanced with depending on what type of trust we're referring to here, okay? So we want to write this down. If you're looking to put your home into, say, a revocable trust, you can do that, right? You can transfer your home. Step one, you create your trust, and you're like, hey, Patrick, we want to avoid probate. We understand that wills are admission ticket to probate, and people die and trusts do not, so we want to avoid probate. We understand by attending your educational workshop and reading your book that if we transfer our home to our revocable trust, we're going to avoid probate. And the answer is correct, because sadly people die but trusts do not. So when your house is transferred to your trust, you avoid probate. Why do folks want to avoid probate? Costs way too much, takes way too long. So that's a big win. The question is, if we have a mortgage on the home, can we still transfer it to our revocable trust? And the answer is yes. Why? Because the Garn-St. Germain Act, and I have another video on our YouTube channel on this. There were two wonderful politicians back in the Reagan administration that created this law that says homeowners with a mortgage are still permitted to transfer their home to a trust. So although your bank mortgage might say if you transfer the property outside your title to anybody else, they could call you on the loan. And so they still have that clause in typical mortgage clauses. However, the Garn-St. Germain Act supersedes that. And from my experience, typically banks are aware of that. So long as you hold a legal interest in the property in this revocable trust, you should not have a problem transferring your property to a trust, okay? The other piece of this is, Patrick, can we transfer our property to an irrevocable trust if we still have a mortgage? And the answer is it depends. Our position in the elder law industry is, so long as you still hold a beneficial interest in the trust, it's our interpretation based on the Garn-St. Germain Act that you can still transfer your property to an irrevocable trust so long as a case can be made to your financial institution that you still hold some type of legal interest in the property. So that is a legal technical nuance right there that you want to discuss with your experienced elder law attorney. And we take layers of protections for our clients who put their properties in irrevocable Medicaid trusts because they desire to avoid a fourth-headed monster, nursing homes, and probate, but an irrevocable trust is required, as you may know, to protect from a nursing home. And we still want our clients to hold some degree of beneficial interest in the property, maybe off record, with some other planning strategies and tools that we use. So if their bank did inquire about them transferring the property into the trust, the Garn-St. Germain Act should assist them, persuade the bank to be okay with that. The other question is, Patrick, after our house is already in our trust, we did not anticipate ever refinancing or taking out a home equity line of credit, but some financial situation arose where they have a big bill now. And now they want to go ahead and borrow money when the house is already in the trust. Can they do that? And if it's a revocable trust, the answer is yes, all day, all night. If it's an irrevocable trust, the answer is yes, all day, all night as well. However, this is the concern. Revocable trust, administratively, it's a little burdensome. You have to transfer the house, take it back out of trust. Typically, the lending institution will require that you do that. Put it back in your name for a day or a couple of weeks, bill and Mary. You secure your financing. And after you secure your financing, the bank will typically be A-OK with you transferring the property back into your revocable trust. Same situation applies with irrevocable trust. Bank will say, hey, Bill and Mary, we love you, but can you kindly take it out of that trust? Because the bank is concerned the trust will protect you if you ever default on the loan payment. And so they're going to say, Bill and Mary, can you take that house out of your irrevocable trust? However, this is the key or the detriment. When you take it out of the irrevocable trust, you're going to be resetting the clock to day one. And that's not ideal. Because with the Medicaid trust, as you may know, you have to beat that 5-year look-back period to adequately protect your property from Medicaid. That's the Medicaid rule, 5-year look-back period. And if you're 3 years into it and now this financial need arises and you look to secure a loan from a financial institution, they're going to require typically that you take the property out of trust, and that's detrimental because it's resetting the clock to day one. Folks, hopefully this educational video was helpful for you. Please post a comment or a question. Please click the subscribe button and click the bell so we'll keep you notified of future elder law videos. Nice job today, Elder Law Care Warriors. Thanks for joining us at elderlawcare.com.